Party will have 15 minutes to present arguments. Appellant may reserve up to 5 minutes for rebuttal. If you wish to do so and reserve anything up to 5 minutes, let me know before you begin your argument. I will be keeping track of time, and I'll do my best to try to keep you apprised of where your time is running. No promises, but I will try.
Yeah.
I will caution you, please, not to use the name of the child here. It was all over the briefs, so I'm not sure what good that's doing, but as a matter of course, because this is live streamed, if you could just refer to him as your son or the young man or something in that regard, it would be appreciated. We have read your briefs and we are ready to begin when you are. Ms. Santucci, you are the appellant here, so you go first.
And yes, I would like to reserve 5 minutes for rebuttal.
Thank you. I'll mark that.
Thank you.
Whenever you're ready.
Okay, Your Honor, thank you very much. Thank you for granting my request to present oral arguments. My name is Cynthia Santucci. I am the mother of and the appellant on behalf of.
We just don't want his birth date out on the internet.
Yes. Okay. He is the petitioner on the domestic violence civil protection order against his dad, Mark Skitzki, the respondent and the appellee in this case. Mother's brief was submitted and the reply brief, and despite appellee and his denial, the truth is, it does not change the truth that this domestic violence act did occur with Mark Skitzki strangling my son and previously locking him out. And Anthony is not a child, he's a man. Like mother, speaks the truth and testified of his dad, over 225 pounds, more than twice my son's weight, sitting on him and strangling him using excessive force to unlawfully restrain him and hold him in a chokehold headlock. As Anthony could not breathe and said, "I can't breathe." This happened during court-ordered visitation on August 7, 2018. This is in violation of revised code, Ohio Revised Code 3113.31 and Ohio Revised Code 2919.25, because Mark Skitzki knowingly caused physical harm to Anthony and endangered him by his force.
Ms. Santucci,
Sure.
I have a question for you in regard to supervised visitation. This happened in 2018. Has there only been two supervised visits between son and father during this time period?
That's correct. The CPO allowed for weekly. The first one allowed for weekly, and Mark Skitzki chose to cancel it after 2.
So son has not seen father other than those 2 times since the incident with the alleged strangling occurred.
Well, we were in court, and he did testify in front of his dad in court in 6/2019.
Okay, that's fine. Thank you.
I'm going to go over why the mistakes in Judge Cook's order and go through the errors to show why it is a monumental mistake, and there are over 10 errors. Justice seemed to be flipped. The fact that my son survived a domestic violence act and she is wanting to end the DVCPO and order visitation for a hearing for visitation between the victim who was strangled and the person who strangled him, the perpetrator of domestic violence, his dad.
So there you're talking about an order of visitation in the domestic case that's still pending. That's
correct. This is contrary to the proper legal statute and case law. Her order, it is unfair to Anthony, it's fundamentally wrong, and it's not just wrong, it's legally, ethically, and morally, it is against the manifest weight of evidence. It is against the manifest law, and both statutory law and case law. It is a failure to use correct legal standard. The correct legal standard was not used, and it is abuse of discretion. It also discriminates against Anthony's age and gender. Judge Cook failed to put safety first. She deprived Anthony of justice and produced an order that is the worst interest of the child. Anthony is nearly 18 years old, 4 months from 18 years old. And also Judge Cook fails to understand the seriousness of strangulation, and it's one of the most lethal forms of domestic violence. Specifically, I was going to review the errors. Number one, by reversing the DVCPO, Judge Cook terminated my son's domestic violence civil protection order. And in doing so, she denied Anthony his statutory right as an order of protection. This is a manifest weight of evidence, law, and an abuse of discretion. Judge Cook used the wrong standard, error 2. She used the wrong standard. She used renewal DVCPO, which has a different burden of proof, and that's an abuse of discretion using incorrect legal standards. She applied the wrong legal standard instead of using the proper legal standard for modification, which is 3113.31 E3C 1 through 12. That's the one she used in error. And then the correct one has 12 statutes for modification. Magistrate Guy, there were fundamental changes to the domestic violence civil protection order. It was not merely an expiration date change. There were new findings of fact. She changed the supervised visitation and reduced it for respondent because Anthony was visibly distressed, shaking, and completely distressed. She added new requirements for respondent regarding supervised visitation, and the expiration date was changed to Anthony's 18th birthday. The statute that governs is the 3113.31 E8C 1 through 12. It says the court shall consider all 12 statutes and other relevant factors. Judge Cook did not. Her reasons did not rest upon a sufficient factual predicate. She ignored the entire mosaic of facts and relevant circumstances to consider in modifying a DVCPO. And this erroneous and narrow examination of facts is an abuse of discretion, failing to consider all evidence. Judge Cook erred by relying and narrowly focusing on only one factor, whether a new act of domestic violence has occurred since the original DVCPO, when the law requires all 12 factors shall be considered. No new acts of domestic violence are the result of no opportunity and the threat of legal punishment, as the DVCPO prohibits respondent's contact with my son. Appellee does not want it ruled as modification because it will expose father's history of violent behavior he's trying to hide. Finally, it also goes against case law. Judge Cook's order is not supported by case law. It is an abuse of discretion in relying on a single factor in denying the extension of a DVCPO. Maldonado versus Maldonado in DC 1993. Judge Cook failed to account for a broader range of potential harms from denying the victim's DVCPO, including the strong likelihood of father repeating domestic violence in retaliation by strangling Anthony again, hurting him, or killing him. Not to mention the emotional harm it would devastate Anthony. Judge Cook failed to apply this case law and Sinclair versus Sinclair case law. The only relevant factor in determining the proper duration of a DVCPO is the amount of time necessary to protect the victim from further abuse. She erred by vacating his DVCPO before his 18th birthday, which is the only time that Anthony will be outside of the jurisdiction of the court at age 18. Her order risks the survivor's bodily integrity and his right to be free from domestic violence. Judge Cook's mistake is failing to understand the seriousness of strangulation and the likely subsequent retaliation by my son's father for reporting and exposing this truth of him strangling him and the previous abusive things he's done to him. Judge Cook was required to follow all 12 statutes, and I'm going to review a few of them. She reached a conclusion that was contrary to law and not supported by all the facts. Statute 1, whether petitioner Anthony consents to the modification, he initiated it. He testified 5-year DVCPO and no contact with his father. He is terrified and he fears imminent physical harm by his father. Statute 2, whether he fears the respondent. There's been a history of his dad hurting him and then the strangulation on top of that. So there is She distorted the victim's statement. Anthony gave many clear reasons, and it's on mother's brief on page 24, I believe, of why he's fearful of his dad. She did not consider those, nor the prior abuse. And Anthony testified, because I'm fearful and I don't want to go back, when he was asked about the CPO. All of Anthony's testimony indicates he intensely fears his dad would strangle him or hurt him again. It's in testimony, what are you fearful of? Anthony said, him doing something else to me that could be worse. I mean, he shoved me down, he pushed me, kicked me on the ground, threw a lock in my back, he locked me outside. I mean, what else does this court need to hear? Judge Cook ignored Anthony's testimony of his dad's prior abusive acts, not to mention Anthony's detailed testimony of the strangulation.
Ms. Santucci, I want to ask you a question. You've mentioned a couple times that Judge Cook ignored the information about strangulation and the dangers of strangulation. What evidence about that was put before her that she ignored?
The seriousness of strangulation, the research that I have researched from lawyers.
Hang on.
What?
Did
Okay.
you testify about that?
Yeah, yes, I did testify. Because
And please don't take this as, I don't mean this as an insult.
Okay.
Do you have expertise in that regard?
no,
Are
I
you
don't.
qualified as an expert?
No, I do not.
Okay, but you said you did talk about it in your testimony.
I talked about the lack of the seriousness of her knowledge of the seriousness of strangulation. If she's ready to go put this,
Hang on, just so we're clear here. You're talking about that with us, or you talked about strangulation and the seriousness during the hearing? That's what I'm trying to determine.
in general, I did, yes.
Okay, and just so you know, I just hit pause during my question, but you are into your rebuttal time. You can continue, but I wanted to keep you apprised of where you are.
Okay, already it's 10 minutes, okay. Okay, I do want to go over statute 3. We're going to just go through these quickly then. Judge Cook ignored the circumstances, which is statute 4. The relationship was based on fear, statute 3, and then into statute 8 is very important. Other protection orders. Judge Cook ruled on a case where Mark Skitzki assaulted his former fiance. She ruled on that case, and she knows about it, and it was not under consideration. And the court says it shall be. And then in statute 12, and other safety factors, Mark Skitzki is a trained martial arts black belt. He knows chokeholds, immobilizing, pinning. Anthony's age was not considered. And then error 3, back to the errors. And she added a distorted statement that victim did not say. Again, page 24 in my brief has the exact why Anthony fears his dad. And then 4 is in terms of a threat of, it is a threat. Judge Cook did not consider the threat of harm. It is against the manifest weight of evidence and law in just determining and having a hearing for visitation for the person, the surviving victim of domestic violence by strangulation and his father who strangled him. And then finally, it is, again, strangulation is the edge of homicide, and I don't believe it was taken seriously, and that there is research that shows it should be taken seriously. It is the best predictor of subsequent homicide of victims of domestic violence. And then Judge Cook also ruled on the case when recusal would have been appropriate because she ruled she was accepting fundraising activity from Mark Skitzki's lawyers, and she personally knows each party. Recusal before ruling on the objection would have been right. And finally, she discriminated against Anthony's age. Any female adult would have been typically given, not guaranteed, but would typically be given 5 years and no contact with the perpetrator. Anthony should receive the same protection, and he did not. And mother's errors have merit. They reveal truth, and they demonstrate that Judge Cook erred in sustaining father's objections. How much time? 1
minute and 46 seconds.
Okay.
Well,
You have 1 minute, 46 seconds for rebuttal.
yes, ma'am.
Okay, thank you.
Ms. Smith, you may proceed when you're ready.
Thank you, Your Honor. I think that what's important to note in this case is the long history that these parties have been in the domestic relations court. And
Counsel, I'm going to stop you right from the start if you don't care. Sorry about that, but we have limited time, so I have a couple questions. Ordinarily, what's going on in the DR court would be irrelevant to us. We couldn't consider it. However, we can consider extraneous matters in regard to mootness. And so I'm just wondering what the status is in regard to the domestic relations case. Has there been a hearing on visitation yet?
The hearing on visitation occurred last Friday. No ruling has been issued yet. I don't want to launch into the entire history of the case.
No, that's fine. I just wanted to see what the status was, because if you told me the court had not entered visitation, had said there's not going to be any visitation, obviously that may moot this whole thing out. Which goes to my second point too. The young man here is going to be 18 in February.
Correct.
It's already October.
Correct.
This whole thing may be moot. Would you agree, before a decision is even rendered?
Correct. Yeah.
Mm-hmm. So what is the purpose of this? Why can't you, I mean, I'm just trying to figure this out, because you have a almost 18-year-old young man, and he obviously does not want to see his father.
I think that the second part of that statement is only true when the child is under mother's influence and control.
Well, he wasn't under mother's influence and control when he was at the visitation center.
Yes, he was. So
How was he under her control there?
Because mother took him there, drove him there, was waiting in the parking lot. On both occasions that there was supervised visitation, the child went in, crossed his arms, sat at the table, didn't speak to his father. His father brought games, different things for him to do, sat there and tried to talk to him, and the child said nothing. And then he went out into the parking lot and high-fived his mother.
But mother was not watching his performance, so to speak.
So to speak.
Yeah.
So to
Yeah.
speak. But was still
And
under influence and control.
She wasn't physically present.
Right. And I think that a key thing to note in this case is that the parents had shared parenting and nearly a 50-50 time schedule up until this alleged incident took place on August 7th, 2018. The child was with father for his 1 week of, they were doing week on, week off during the summer. Mom didn't like that. The domestic relations case, the custody case, was set for trial. I think it was that September. This was the last week of visitation that the child had with father at his summer break before they reverted to the school schedule, which was also nearly 50-50. This alleged
Again, counsel, I apologize, but I really wanted to continue on with a little bit of a line of questioning, so I apologize in advance. But what I guess I'm getting at is, son is going to be 18 in February. He is an adult then, and he can make his own decisions, who he will see and who he will not see. If he really wants a relationship with father, he could have it in 4 months.
Yes, and we hope that that's what's going to happen.
And if he doesn't, then father can't be around him.
Yeah, and that
as an adult, you don't have a right to see your, unfortunately or fortunately, however it works. I'm a parent, so I can't even imagine. That would be horrible. But the point is, if your child doesn't want to see you, he doesn't have to see you.
Right. And this isn't my appeal. This is her appeal. So this was...
No, the reason I'm asking that is because it just seems like this is something that the parties should be able to resolve and say, look, we're just going to keep everything status quo until February when the young man turns 18, and then he can make his own decisions.
So the most tragic part of this case is that all of this stemmed from false allegations of domestic violence back in August 2018. Had the court been swift in remedying this misjustice back in August 2018, we would not be where we are today.
And that might be, but we are where we are today.
Right.
And she has appealed. And if we reverse, and he's going to have a CPO still in his record, whereas right now he doesn't. Right?
Yeah. And it's our position that the judge made no error in reversing
Okay.
CPO.
I'm just trying to figure all this out because to me, it's like 4 months.
Yeah, it's a lot. We believe that the original CPO that was granted in October 2018 was improper and against the manifest weight of the evidence and against the law. If
But
you look at
with
the
excuse me, counsel, with regard to the original CPO, you withdrew the objections, correct?
yes,
I understand the reasons.
Yes.
But the reality is you withdrew the objections.
yes, but
So
also,
it stands.
yes, it does. But the fact of the matter is that mother continues to claim that an act of domestic violence occurred and that he was choked and strangled and crushed. And any given day, she might have another hyperbolic explanation of what happened. That's not true. It's false. It's false to report to this court that this child was ever strangled. If you look at the order, the original order, the order does not hold that any act of domestic violence ever occurred. The original order says that petitioner alleged this, that, and the other thing. But the order also says,
Counsel, I'm going to interrupt you again because we have limited time. And I understand where Judge Callahan, I think, is coming from completely. Why are you arguing the first CPO? You didn't appeal that, you didn't object. So regardless, there was a finding that the child was in need of a CPO for whatever reason.
there was a finding that the child very convincingly expressed fear. Those are the words of the order.
Okay, and therefore got a CPO, correct?
Right. And that CPO was set to expire. It was set to expire in April of 2019. Yet here we are in October 2020 talking about this original CPO and the issuance of the second CPO. The second CPO was also against the manifest weight of the evidence and was contrary to applicable law. That's why we objected. We did not withdraw that objection. And Judge Cook's ruling that that objection was sustained was proper and correct. Judge Cook made no error in her application of the law. There was 2 supervised visitations that took place from the issuance of, or from the first alleged incident in August 2018 up through mother filing a motion to modify the original DVCPO. Two took place at common ground. There was no allegations that father acted inappropriate in any way. There was no allegations that a new act of domestic violence occurred. Outside of those 2 visitations at common ground, both the petitioner and the child admitted that they hadn't seen, spoke to, or otherwise had any contact with father. Father was merely waiting for the original CPO to expire so that he could resume visitation with his son and resume the relationship that they previously had. So the fact that Judge Cook saw that, reviewed the transcripts, and made that ruling was proper and correct. Now, Ms. Santucci argues that Judge Cook applied the wrong standard in her ruling. And I'm sure that you've read the briefs, and I'm sure that you've looked at the case law on it as well. If Judge Cook were to treat it as a motion to modify rather than a motion to renew or extend, as it's stated in the London case, that she would have that the magistrate would have had to stick with the original ending date in the original DVCPO. So she could have modified the terms of visitation, but that still would have ended in April 2019. Instead, the magistrate guy treated it as a renewal, and the basis of each, either a modification, a renewal, or an extension, you have to show to the court that there is some reason to extend or otherwise modify the terms of the domestic violence civil protection order, and the evidence presented to the court in both cases fails. There was no history of violent behavior that was ever found to be substantiated, nor was that evidence presented to the court. Mother has,
would a threat of future harm suffice for the extension?
yes, if there was one, but there wasn't.
What effect does the child's indication that he fears his father and that he feared harm? what effect does that have on that element?
So
You know, the threat of future harm.
the element is that there has to be, it has to show whether a reasonable person would be placed in fear of imminent, serious physical harm.
But did his testimony establish, at least, could it have established that he perceived a threat of future harm based on the interactions he's had with his father in the past? Would that be enough?
No. And that was our argument. And if you look at if you review the testimony in its entirety, you can see that that's true. He says, oh, I don't want to be choked again. Okay, well, he was never choked. There was never a finding that he was choked.
Well, he testified he was choked.
Right, but there was never a finding of that. So at the
Mhm.
second hearing, he was testifying that he was choked, and there was never an actual order finding that event ever occurred. And then you know, he had testified that he's just afraid, he's fearful. But that in and of itself is not a reasonable fear. That's not a reasonable suspicion or belief that he would be placed in fear of imminent, serious physical harm, and that's the law. Without him,
So if a victim comes in, and we'll say an alleged victim here, comes in and says, I was strangled, I was hit on occasion previously, I was pushed down the stairs, I had a lock thrown at my back, all those things, it's not reasonable to think that victim may be in fear of imminent physical harm if he is unsupervised with the perpetrator again?
if those things were true, and the point in this case is that those allegations have been repeated since the child was a little boy, and they're not coming from the child. They're not. They're coming.
Well, he testified under oath.
Yeah, they're and if you look at the cross-examination, you'll see that those are not coming from the child. They've had Dr. Tenner, Dr. Levenger. Actually, Dr. Levenger testified at the first domestic violence trial. All of these experts, actual experts in the field, have testified that that the child parrots mother's concerns because of this dangerous psychological enmeshment between the mother and the child.
What about the evidence that father had been violent with someone else before, I guess a fiance or something?
Right. That's
Wouldn't that be corroboration?
one that was not presented at the hearing on the extension for the CPO. That was presented at the original hearing for the original CPO, and those allegations are also false. If you look into those case numbers, you can see that woman brought a charge and then she later dismissed it because it was a false claim.
Well, I thought he had a conviction for that.
He has
Albeit a minor misdemeanor, but I thought there was a conviction.
He has a disorderly conduct conviction in Akron Municipal Court. No,
Well, that's not a dismissal by the person who brought the charge then.
right. So she brought simultaneously. She brought an action for a DVCPO in the court, and then she also tried to bring a domestic violence charge in Akron Muni Court. The DVCPO was dismissed as fraudulent.
Okay.
Domestic violence charge from the Akron Muni Court was reduced to disorderly conduct because it was later found that she was the primary aggressor when she hit father in the head with a blunt force object. He pushed her away, her glasses cut her face, and that was the result of that charge.
Well, I guess having heard all sorts of those cases, I am confused as to why if she was the primary aggressor, he would have had a conviction for anything.
As am I. Well, it was a conviction because he pled to it.
Right.
I think that, right. A lot of these things, the dismissal of the original objection, pleading down to a disorderly conduct, unfortunately, litigants are faced with the harsh reality of having to pay attorney's fees for attorneys to come in and represent them. And
Understood.
that has to come into consideration when it comes to these pursuing these types.
So that, but to piggyback on Judge Callahan's question, so there wasn't necessarily a finding that she was the initial aggressor.
No.
There's no court record of that.
Well, there was no trial. So I'll leave it at that.
Thank you.
You've got 45 seconds left.
Yes. I have 45 seconds and about 9 different assignments of error that I have not been able to address. However, I did address them in my brief. So, and I know that you have all read the brief and the reply to the same. We think that Judge Cook was completely correct in sustaining our objection to the extension of the domestic violence civil protection order, and we ask that this court uphold that decision.
All right, thank you. Ms. Santucci, 1 minute and 46 seconds.
Thank you, Your Honor. I do want to say Anthony and I speak the truth, and we did in fact, everything he testified to did in fact happen, and sadly the attorney is lying, and so is Mark Skitzki. The event did happen, the domestic violence did happen, and Anthony suffered it, and all those periods of prior abuse, nobody believed, and there were fraudulent and deceptive court representatives involved. Bottom line is, it did happen, and if Anthony testified he does not want any contact with his dad. He testified he wanted a full 5-year DVCPO, which is what the court typically gives adult female victims, and he should be treated no differently. And in terms of the credibility of the client, his former fiance slapped the Mark Skitzki in the face, and he returned back, and I will read this directly from Judge Cook's order. Respondent Mark Skitzki, significantly larger than petitioner, pushed respondent's head into a door and shoved her to the ground. Petitioner had significant injuries as evidenced by, he is a liar. Anthony deserves the protection that was afforded to him by the domestic violence civil protection order. Judge Cook should have looked at 12 factors, and she did not. There were fundamental changes in the modified DVCPO, and she's required by law, the court shall consider. She didn't consider the prior DVCPO that she in fact ruled on, and she did not consider Anthony's fear of his dad and all the other 12 statutes in my brief that clearly explain this. That's what she should have done. And Anthony is doing great in life, in school, at a dramatic.
Your time's up. Thank you. We understand and we appreciate your argument. We will take both arguments and briefs under advisement, issue a written decision in due course. It will be mailed to both sides as well as posted on our website and that of the Supreme Court of Ohio. Both of you have a good day.
Thank you very much.
Thank you.
Thank you.
Thank you.